Thank you for bearing with us. I'm glad to say that the Tribunal has been able to reach a decision in this case, and it's a unanimous decision. This is an unfair dismissal claim, and therefore under Section 98(1) of the Employment Rights Act 1996, it is for the respondent to show the reason for the dismissal, and that it is a potentially fair reason under Section 98(2) of the Act. Only if the respondent can show a potentially valid reason for dismissal, then will the Tribunal go on to consider whether or not that dismissal was reasonable under Section 98(4). In this particular case, the respondent pled claimed that the dismissal was fair on the grounds of conduct, or alternatively on the grounds of some other substantial reason. The Tribunal has listened carefully to the evidence and taken into account the alleged behaviours of the claimant, both inside and outside work in this case. And it is clear that there were a number of issues that played on the respondent's mind when they reached the decision to dismiss the claimant for misconduct. However, the catalyst, at least to this tribunal, for the dismissal seemed to be the claimant's appearance at the political rally in Cumbernauld, and in particular the subsequent reaction of his colleagues, the trade union and other organisations, including the funders, and that was the basis of the dismissal. It was not the claimant's conduct as such that was a concern for the respondent. Rather, it was the reputation and the relations within the workplace that was the issue. That is not a conduct dismissal, but it is, in our view, capable of amounting to a dismissal on some other substantial reason grounds. And therefore, the first limb of the test would be satisfied in this case. The respondent has shown a potentially fair reason for dismissal. That could be relevant later on, of course, if we came to find that the dismissal was fair, because in an SOSR dismissal, it should have been with notice. It would not be a summary dismissal. And in that case, we would, and if we do find that the dismissal is fair, we would nonetheless award at least the notice pay. However, having dealt with the first limb of the test, the Tribunal then moved on to consider the second limb, which was whether or not the dismissal was fair and reasonable in all the circumstances. Now, the Tribunal we reminded ourselves that we are not permitted to substitute our view for the view of the employer. There is a range of reasonable responses open to an employer in a case like this. Some employers may legitimately take different views from other employers in reaching the decision. Some may be harsh, some may be less harsh, and we have to take that into account. We did listen carefully to all the evidence that was led. We looked at the witnesses. By and large, we found them to be credible, albeit on occasions showing a somewhat closed mind to the views of other parties. The case certainly did provide a number of challenges to this tribunal, and there was quite lively debate, I think, when it came to deciding on what the correct approach was. On the one hand, we have to seek to balance the rights of the claimant and indeed any employee to express his or her personal views and political views, particularly outside work, whilst at the same time striving to balance the employer's right to protect the reputation, and in this particular case, to protect their sources of funding. They are a publicly funded body with some of the challenges that brings. We were very mindful of the respondent's position. They are a body reliant on public funding. We were also aware or took into account the fact that although the claimant in this case did speak of his views being made in a private capacity, they were actually done in a very, very public way. It can't be easy to find one of your employees' faces on the front of your local newspaper in a rally or a situation that actually might reflect badly on you. So we were very mindful of that. We also accepted the concerns that had been raised by the council funders. We believed that they were genuine concerns, and they placed the respondent in a difficult position. Again, we were also mindful of the difficult position the respondent was placed in relation to the internal relations with Mr. Patel, and we didn't doubt for a minute that his letter was genuine. Against that, of course, we are cognizant of the claimant's right under Article 10 of the European Convention of Human Rights to freedom of expression, regardless, and I think as Ms. Kemet said in her submissions, regardless of how controversial those views are, people are entitled to hold those views. And in general, what an employee chooses to do outside the workplace is none of the business of the employer, unless the employer can show that that behaviour impinges on them. In this particular case, I think clearly the claimant's views were capable of impinging on the business and on the internal relations, and in particular the funding. However, in this particular case, the concern that the panel had was that the respondent appeared to have adopted an almost entirely uncritical acceptance of the position. We got the impression from both Mr. Butler and Ms. Barnes that they had approached the hearing with a closed mind. They had, and certainly there was a concern from the panel, that in particular in Ms. Barnes' case, that the appeal hearing hadn't taken the form of a rehearing. There simply seemed an acceptance of what the position was. There was no serious attempt to actually discuss the position in relation to funding with the council. And it may or may not have formed a fair dismissal if funding had been clearly going to be withdrawn, but we simply didn't know that. The work hadn't been put in to establish that. There was simply an acceptance of one councillor's word. And similarly with Mr. Patel, clearly he did have concerns. However, in his letter, he simply said he felt uncomfortable. There was no real evidence there that it was impossible for Mr. Patel and Mr. Bulldog in this case to work together, and we felt that more could have been done to explore that. Certainly any comments about immigration at work to Mr. Patel were ill-advised in the extreme, but there didn't seem to be, to us, there hadn't been an issue about that until this picture at the rally came to the fore, and Mr. Patel seemed to have worked happily alongside the claimant up until then. The panel also, I think, had particular concerns over the particular tolerance that was shown to Mr. McTaggart in this case, and the different treatment meted out to him compared to the claimant. So really, on balance, and again mindful of the fact that we are not permitted to substitute our decision for that of the employer, however, we feel in this case the failure to consider alternatives to dismissal, and in particular the failure to explore the funding issue with the council and the integration of Mr. Bulldog back into the department with Mr. Patel. In our view, that brought the decision out to dismiss outside the realm of reasonable responses, and therefore was unfair. We also did take into consideration whether or not on that finding we would reduce compensation to take into account Mr. Bulldog's contribution, i.e. was he at fault partly for his own dismissal, and we could reduce compensation accordingly. But on balance, we felt not. It wasn't a conduct dismissal. It wasn't Mr. Patel's conduct itself that caused the dismissal. Rather, it was the issue with the funding. And we didn't think that in this case, although we didn't hear full submissions on the matter, on balance, we didn't think that we'd be likely to make any contribution. We also considered whether or not we would order Mr. Patel's reinstatement, so Mr. Bulldog's reinstatement to his role as an alternative to compensation. A tribunal, if it is asked to consider reinstatement, must do so first of all before it considers the question of compensation, albeit it is very, very rare for such an order to be made. And in this case, we'd have liked to have heard further submissions on that question before we reached a firm decision, but we did doubt the practicality in this case of actually having Mr. Bulldog go back into the workplace. So in all likelihood, we would have simply made an award for compensation rather than reinstatement. And with that, I would just like to thank my fellow panel members, and that was the Tribunal's decision.